I'm afraid to go to the other things.
Good afternoon. Sorry to talk over you, Ed. Little
Sorry, brother.
green room commentary there. Good afternoon and welcome to episode number 43 of At Your Service with Haber and Martinez. I'm Haber. That is Martinez. Today's episode we have entitled Florida, the Sunshine State or the Sentencing Enhancement State. Without blowing the reason as to how, without blowing the story, the backstory as to the reason how we got here, I just want to tell you why we picked the subject today. Ed and I were talking the other day, as we routinely do, about potential cases, potential clients, existing stuff that we have, we bouncing ideas, getting a second opinion, second thought process. And Ed had mentioned to me an interesting situation that crossed his desk where a person was charged with battery on the elderly. If you're over 65 in the state of Florida, you're in a protected category as a victim of crime. So there are enhancements that come with just the fact that you are the age that you are. And what was interesting about it was that the person who committed the offense, or allegedly committed the offense, is also over 65. So we were rattling that around, and we will talk about that a little bit later on in the show. But as we were discussing it, it dawned on me, that's but one of many sentencing enhancements that we have here in the state of Florida. And when we think of Florida, we think of the Sunshine State, right? But when you start rolling through this alphabet soup of enhancements that the Florida legislature has endorsed and that the governor has signed off on and that are now a part of our formal system, you wonder sometimes if we couldn't be called the sentencing enhancement state, especially when you watch the news, if you watch the news, and you hear stories about places like California and New York where there's just utter and complete lawlessness. There's no cash bond. People are out on the streets while they've got existing cases. They pick up second and third cases. They're still out on the streets. Let me tell you right now, and pardon my language, but none of that shit flies here in Florida. That just ain't going to happen here. I don't care if you're in front of the most liberal judges in this state. The legislature has bound their hands in many, many ways. Now, that said, there is a lot of judicial discretion. And the most important thing, and obviously one of the things that we hope that you get out of our show, is creative lawyering. The more well-versed, the more skilled, the more experienced that your criminal defense counsel is, the better likely we are, the more likely we are to be able to negotiate, navigate, and circumvent some of these hazards that may affect you whether you know them or not. So now that I've rambled on for a couple of minutes, Martinez, good to see you. How you feeling?
Good, my friend. I'm having problems with my speakers, so it's kind of low. So I'm trying to see if I can connect these. But it's been one of those days. As you know, I've been sick for a couple of days with COVID, and I'm really just getting over it. So if I'm a little loopy, more than normal, how about that? If I'm loopier than normal, it's probably because of COVID. And even if it isn't, that's my excuse, and I'm sticking to it.
All right. Well, since we didn't have a show last week, let me just give everybody a belated Happy Independence Day from your founding fathers and Martinez and Haber. All right, so let's kind of jump into it a little bit. I want to run through some of the bullet points that I listed in the promo today. Among the things that we're going to discuss are, we use this term alphabet soup. There are a series of sentencing enhancements, some of which are mandatory, and some of which leave a little bit of discretion with the judge, all of which the burden is on the state to allege and to prove. But if they can, and you could be charged as what's called a habitual felony offender, sometimes called a habitual offender, an HO or an HFO, or there's a habitual felony violent offender, that's a HFVO, a violent career criminal, a VCC, a prison release reoffender, a PRR. Those are all categories where if you commit a certain crime, most of which are designated, not all, under a HFO, you don't have to have designated felonies, but under the others you do. So, and again, we'll get into the soup and nuts and the nuts and bolts of this a little bit later, but I want to give you the preview. If you fall into any of those categories, you're automatically reclassified for a crime that if you were not an HFO, an HFVO, a VCC, or a PRR, would be at its normal level. But if the state's able to establish that you meet the criterion, you get jacked up just because of your past. That's specifically due to your criminal history. So prior record is really important. Also, legal status is important. We talk a little bit about the sentencing guidelines score sheet. There are a number of enhancements on that score sheet. And among those enhancements are right up top, legal status violation. If you are an escapee, if you're fleeing, if you've got failures to appear, if you've had supersedious bonds, all of these types of things, if you're on probation, community control, pretrial intervention, or even diversion at the time of your offense, all of those things factor into the calculus and count against you. So you get ratcheted up in the sentencing guidelines score sheet just as a result of your prior criminal history. Then we go into certain types of crimes. There are some crimes in and of themselves that we call progressive or stackable offenses. So, for example, theft and DUI, which we'll talk about both of those during the course of the show. If you have a petty theft, if you steal a $30 pair of earrings from Target, that's petty theft. But if you've been accused and convicted of petty theft in the past, your second-degree misdemeanor is no longer a second-degree misdemeanor just because of your past. It gets bumped up. And then there are other types of things that are very interesting in the theft statute. For example, I know Martinez is having some hearing problems. He may have to.
Yeah, it's really hard to hear you, Mike. But keep going. I can hear you, but it's low, and I'm trying to see if I can connect my headphones.
Well, we can hear you at least I can hear you just
okay,
fine.
Perfect.
So at least we got.
I'll try and follow along. If I'm off by anything, if I miss,
all right. You ignore most of what I have to say anyhow. So
well, that's the one positive about this is that I now have an excuse for tuning you out, whereas before I always have to come up with them.
So I'm going to just keep running a little bit down our laundry list. So I'm setting it up a little.
I'm there. Okay, go ahead.
There are some interesting things in the theft statute. For example, let's say that you steal a $40 fire extinguisher. Not from a store that sells fire extinguishers, but a fire extinguisher that's placed in a place for the purpose of being used as a fire extinguisher. That $40 product is going to land you with a felony charge just because of the nature of the product. So there are some times that it's the nature of the offense itself bumps you up. Again, another example of that would be the characteristics of the victim, such as the age of the victim, like we were talking about earlier, or a pregnant victim. A battery that I commit on somebody who is not pregnant is not enhanced. Whereas if that person is pregnant, that very same battery, even if there's no injuries, is enhanced. I get bumped up to a felony. You have other things like injury. The amount of injury that's alleged and provable by the state will affect not only possibly the charge, but definitely your sentencing guidelines score sheet. Who your victim is, again, age, law enforcement victims get special status, firefighter victims get special status, pregnant, elderly, that kind of morphs into what we call prejudice-motivated offenses, which you may know as hate crimes, which includes significantly more than just age. Then you've got sexual orientation, you've got homelessness is a basis for hate crimes. And there's a whole laundry list of those that will bump you up. You have enhancements for weapons or firearms. Everybody here has probably heard of 1020 life. We'll talk about that a little bit too. There are concerns, for example, with regards to traffic cases, very common. Driving on a suspended license. You rack up enough of those, you become a habitual traffic offender, and you're off from county court into felony land. DUIs. We could go all day on DUIs, but those are progressive offenses. As you rack up more DUIs, the penalties get stiffer and stiffer. Similarly, there are enhancements even in the same level of DUI, and we'll talk about that again in a bit. And then you also have stuff like probation violations. There's a category called a VFOS, which is a violent felony offender of special concern. And that affects your ability to get bond just because of your circumstances at the time of your new arrest. Again, these are very technical things, especially the alphabet soup ones. And we're not going to, kill you with the details. We will give you a little bit just so you kind of get a taste of it. But they are very, very technical, and they are numerous. So with that, let's kind of jump forward a little bit and talk about how the sentencing structure works here in the state of Florida. So every single crime in the state of Florida is assigned a category or a level of offense. There are misdemeanors and there are felonies. there are two levels of misdemeanors: second-degree misdemeanors and first-degree misdemeanors. Second-degree misdemeanors are punishable by a statutory maximum of 6 months in jail or 6 months of probation and a $500 fine. First-degree misdemeanors are punishable by up to 364 days in jail or a year in probation and a $1,000 fine. The next level up is felonies, and the lowest level felony is a third-degree felony. That's punishable by up to 5 years in prison, 5 years probation, and a $5,000 fine. Second degrees, 15 years in prison, 15 years probation, $10,000 fine. First degree felonies, 30 years in prison, 30 years probation, $15,000 fine. First degree PBLs are punishable by life, up to life in prison, and capital felonies are punishable by death. Those are the statutory maximums in the state of Florida. Any judge on any guilty verdict for any such offense can give any defendant the statutory max if he or she wishes. That is completely 100% discretionary with the court. Now, of course, your defense attorney is going to make argument and try and reduce your exposure if in the event of a guilty verdict or a guilty plea. But that's where the high end of the guidelines is. The low end drops down to the sentencing guidelines score sheet. And that's basically a mathematical calculation which determines a numerical value for you in your given case. When we look at the guideline score sheet, the first thing we look at is the most serious charge that you're facing in that moment. If that charge gets a numerical value, it's across the board. The same value applies for everyone because it goes with the charge, not the individual. That's where you start. And then if there are additional charges, in other words, if you have multiple counts, the other charges will fall underneath it and they will get their own lesser values that get tacked on. The next thing that the guidelines consider is victim injury. We discussed that a little bit. There's injuries for second-degree murder, death, severe injury, moderate injury, slight injury, sexual penetration, or sexual contact. If any of those apply, they get added into the calculus. Then we go to your prior record. Any scorable prior gets calculated in. So
Right.
if you have a prior that is usable, sometimes they are, sometimes they aren't, but if it is a scorable prior, that will be factored into the equation. Then we get into legal status and community sanction violations. If there's any of that applicable, that gets tacked on. Then there are additional enhancements if you're using a firearm, semi-automatic, or a machine gun, or if you have prior serious felonies. And then there are additional enhancements on the scores. Now, again, we're just talking about the score sheet here for law enforcement protection, drug trafficking, motor vehicle theft, criminal gang affiliation, domestic violence in the presence of a child, and adult on minor sex offenses. So if any of those apply, they get calculated in. At the end of the day, when all the math is done, that's going to determine your low level, the bottom of the guidelines, which could be as low as NSPS or non-prison state sanction, meaning you could get nothing. The judge could say you're done, go home, or you could get probation, or you could get any amount of time from 1 day up to the statutory maximum. And as long as the judge stays within that guideline sentencing range, as wide as it may be, as a general rule, the sentence is going to stand.
Can we talk about a little bit, Mike? Because I mean, everything you're saying obviously is 100% correct. But sitting here listening and thinking, okay, if I'm not a lawyer, or even if I am a lawyer, but I've never had really any kind of exposure to the criminal justice system, this is lost on me, right? So what I'd like to, if I can, show the significance of what you just said. Let's just take the last thing you said. The significance of a score sheet coming back, which the prosecutors fill out, non-state prison or non-state prison sanctions. The real world significance is that the state attorney can't make an offer that's too harsh. Why? Because that means we could go straight to the court if we wanted to. We could just straight up to the court and say, Judge, look, the state offer is X, whatever it is. Let's say 3 years of prison. But my client, if your court will give it to him, my client's willing to take right now 2 years of probation or 1 year of probation with a withhold. And the judge can do it. The state cannot appeal. The state can't do anything about it other than maybe have a little hissy fit at the podium. But that's all they can do. And I'm not blaming anybody. I'm not judging. I've been known to have a little hissy fit myself when I was a prosecutor, so I get it. But that's really the point is they can have nothing, they can do nothing but have a hissy fit because the judge can do it. Once you get to a point where there's an actual score, 22 months, 30, what I think the lowest after non-state prison, I'm looking at an infidel that I have sitting next to me. After non-state, what's the lowest score above non-state prison? Is it 24 months?
I don't have it in front of me.
I think 66
I can tell
days?
you right now.
Yeah, I think it's 366. I think it's a year and a day. But the point is this: you go from non-state prison to a jail number or prison number, right? So it'll go from either the judge can give you anything he wants, including 1 day probation if they want. The judge can do a withhold 1 day probation, which means fill out the paperwork.
It's 12 months.
Right. So when it's non-state prison, the judge could literally say, you know what, if you want to close it out, I know the state is asking for 3 years, but I'll give you a withhold and 1 day probation, which means you fill out the paperwork in court, and the minute you walk out of that courtroom, your probation is over. Right? But once you get a score, which is usually 366 days or higher, even if the judge wants to get involved, for the most part, remember it's always a little complicated, but generally speaking, they have to give you nothing lower than that number, which would be 366 or more. Now, there's other exceptions that Michael and I, and any good lawyer that's ever done criminal, can tell you how we could get around all that, but that's another story, either Michael later today or for another time on how we get around that. But again, that's the purpose, the real crux of what's going on with you guys that are not lawyers or haven't been through the criminal justice system extensively. That's the significance of that. Getting a non-state prison number gives Michael and I and any other defense attorney a lot of leeway and a lot of ammunition to try and maneuver a good plea for you. Go ahead, Mike. I'm sorry. Just wanted to make sure.
Let's go through some of this alphabet soup stuff.
Okay.
So, and unfortunately, I have an awful lot of notes on this, so y'all have to pardon me because again, this is just so much, an incredibly overwhelming amount of information.
But let's try and dumb it down. I don't mean dumb it down. I mean it in the true sense of the word.
I know what you mean.
If you're a neophyte, I mean, listen, Michael's been doing this for 30 years. I've been doing it for 20 years. This is what we've done. We know it backwards and forwards because we hear it over and over and over and over.
I want you guys to understand one thing up front that's really important. This is a little pro tip and a nuance. Florida has a thing called a withhold of adjudication, and lots of people know what that term is in terms of having heard it and recognizing it, but they don't know what it means.
Right.
And a lot of people have a very false sense of what it means. They believe they're afforded some special protection, which they're really not. What a withhold is, and when it was created, it was much more meaningful than it is today because it has been diluted and eroded. But the idea behind a withhold was an ability for the court to use its discretion, or the state if it chooses, to give somebody a break. Somebody who maybe doesn't deserve a complete pass, because otherwise they might get a program, a diversionary program, a dismissal, a conditional null pros. There's all sorts of games that can be played. So it's somebody who they want to slap, but they don't want to leave a mark. So they created this thing called a withhold, which means the court finds you guilty. However, they do not adjudicate you guilty. So if you are a convicted individual, whether it's a felony or a misdemeanor, you have been both found guilty and then adjudicated guilty by the court. And the withhold kind of backs that down a little bit. You are still found guilty, but you are not adjudicated guilty. So if somebody asks you, have you ever been convicted of a crime, and that's your only offense and you have a withhold, you can honestly say no, because pursuant to the laws of the state of Florida, if you received a withhold, you are not convicted. However, what they don't tell you is two very important things. Actually, three. And a lot of this really didn't apply when the concept of the withhold was created, but today it's much more meaningful. So one is the feds do not recognize a withhold. Not only in federal criminal court, but also in immigration court. Correct. So your withhold of adjudication in state court here in Florida means nothing. if you get hauled in for removal proceedings in immigration court. It is a conviction as far as the feds are concerned.
Right. They consider it a conviction.
The second thing is that with the advent of technology, we have all sorts of people whose public information winds up getting disseminated on the internet, sometimes kept in various private databases like mugshots.com, but in other places that are less innocuous. And even though you got a withhold, and even if you subsequently seal the record, and even if you wait 10 years and it subsequently gets expunged, sometimes that stuff still shows up in background checks. And then finally, the third thing, which is really what's important for our purposes, is if you fall into the category of alphabet soup, your withhold is meaningless, because withholds are scorable against you for purposes of HO, HFO, HFVO, VCC, and PRR, regardless of whether you got a withhold or not. So when your lawyer is telling you how wonderful this withhold is and trying to cram a plea down your throat, you better think real hard and long and ask some questions, because that withhold is like a dangly little carrot in front of your face, but it may turn out to be a poison carrot if you eat it.
Absolutely. And this is something I tell my clients, and I just want to throw in this one part of a possible plea from the state, only so you understand the reference on what I tell my clients. I always tell my clients, you'd never ever want me to allow you to take a plea without full discovery. I need full discovery. Now, for example, even if it's something like what the state offers when they offer pretrial intervention, where it's, look, do some classes, pay some money, wait 6 months, and if you never get rearrested, we're going to dismiss all the charges. Sounds great. Sounds wonderful. Sounds beautiful. And it is. But you should never take, any good criminal defense lawyer will never allow his client to take any kind of a plea unless he's got full discovery. Because we need to know exactly what's out there. You know what? A withhold may be a complete and total utter gift. It may be something that you should thank the prosecutor, and God forbid if they allow you, walk up to him, give him a hug and a kiss on the cheek. But it might also be that the prosecutor's looking at it going, oh, this is crap, and I want to get something out of this, so I'll make a sweetheart deal on a really bad crime that sounds really bad, but it's only because I know X, and the defense attorney doesn't know it yet. So any criminal defense lawyer who does not tell you, I really don't think it's good for you to take a plea until I get full discovery, you should run. You should run from that person, because either A, they don't know what they're doing, or B, they charge you very little and they're just trying to get out of the case so they don't have to work.
I do want to add one caveat to that. And I agree, by the way, 100%. I don't like to put people in diversionary programs or agree to any type of resolution until I have vetted the case as a lawyer, not as a civilian, but as an attorney. And so that requires me to do diligence and really have a good foundation of information upon which to opine. But I do want to make one caveat to what you said. Here in Dade County and in many venues in the state of Florida, many jurisdictions, there's a diversionary program for DUI, for first-time offenders who don't have enhanced penalties. Again, we're going to talk about DUI enhancement shortly. I never put anybody in. Here in Dade County, the name of the program is BOT, or Back on Track. I never put anybody in Back on Track. I tell them that Back on Track exists, and I call it a golden parachute if they're eligible. I say, look, you always have this golden parachute. We can always take it. We can always, pull the cord and jump out of the airplane if it's going down and it's not. We don't have landing gear, or functional control of the aircraft. So there is a golden parachute, but let's make sure we need to deploy the parachute, because you may not need to jump out of the airplane. Now, if you go right across County Line Road to the north and enter Broward, they just entered the 21st century in terms of DUI diversion. They literally just in the last couple of months authorized a diversionary program for DUI offenders similar to Back on Track. However, there's a significant difference. In Broward, you are not eligible for Back on Track if you invoke discovery. You're only eligible to take, or not Back on Track, whatever they call their program. You're only eligible for DUI diversion in Broward County, Florida, as of today. This may change, but right now, if you do not invoke discovery. If you do, diversion's pulled off the table. So there are situations where, look, when you've been doing these things as long as we have, you can read a PC or an A form and have a pretty damn good idea of what the case is about, especially if you talk to the client and they verify certain things. Now, you never really know, especially in a case like a DUI, when you have body-worn camera, when you have field sobriety tests that you can observe, when you have a plethora of paperwork, where the slightest imperfection in a printout or in a maintenance log can be the difference between whether breath comes in or out. You won't know any of those things if you don't investigate them. And some of them you can do without invoking discovery. So again, the skill, quality, and experience level of your lawyer, as Ed is always hot to point out, really is crucial, because even in a place like Broward, where you are precluded from invoking discovery, there are still public records requests that you can make without invoking discovery. You take a little bit of time, you do your diligence, and you may find a little nugget of gold in there that kicks your case right out of the window.
But let's be honest, Michael. Let's talk about a DUI example, because DUI is, I notice I didn't bring up the BOT because DUIs are a little bit different as far as whether you should take it without discovery. But if your client comes to you, you're going to get the citation at the very least. And if you see on the citation your client blew a 0.15 or a 0.13.
You know, hang on a second. I'm going to stop you for 1 second, because I just read an article today in the Daily Mail entitled "To Protect and Swerve, Drunk and Slurring Florida Cop is Caught Driving His Police Cruiser in Full Uniform with an Open Beer while nearly 5 times the legal limit." Okay, so this is a police officer from Apopka, Florida, who was arrested on duty drunk in his car, in his uniform, on July 4th. Residents saw the police car swerving all over the road, so they called the police to say, hey, you know, you got a guy all over the road. I'm trying to see what his exact breath reading was, but this guy blew.
Well, it was 5 times.
It says nearly 5 times the legal limit, but it doesn't tell me exactly.
I don't know how he was even breathing. That would have to be at least.
Oh, here we go. His blood alcohol registered at 0.039. 0391.
Wow.
I mean, that means this guy was absolutely whacked. Okay. So, yes, when you see somebody with it now, but let me say this, Ed, that's all fine and dandy if the breath card comes in. But if that breath machine was provably malfunctioning, if it was taken offline, if the annuals and semi-annuals and monthly maintenance records are not properly logged, if they're not certified, those breath results, I don't care what they are, they're not coming in. And if you don't have breath, the case changes.
But here, once again, brings me back to my original point. As you said, I like to point out, hire an experienced attorney. Michael, I know these guys, and I know you do more DUIs than I do. We know who are the DUI experts out there, who, you know, these guys make sure everything is done perfectly by the book, and you're never going to catch one of them slipping up. We know who these guys are. These DUI officers who make sure everything's maintained and everything is perfectly done. We also know that if we don't know these guys, it's a very good possibility that there's something missing, something they didn't do right, or we also know who the ones that are slackers. So again, my point is, if you get a DUI with a cop that you know who he is, right? I'm not gonna advertise for these guys, even though we know them. These DUI officers that do everything to the T. Plus, you get the citations where you see it says on there what they blew. Let's say the client blew, and it was a car accident. And on the accident report, it shows that there were 4 bottles of open beer bottles or a vodka bottle wide open. I mean, look, at that point, you might want to.
You don't even have to be a lawyer to figure out that math.
Right. You might say that. Even myself and Michael at that point might say you might want to take the BOT, dude. You might want to do this.
So while we're on, let me run through DUIs real quick, just so that you guys will understand what I mean by enhancements, and Florida being the enhancement state. A first DUI, plain Jane, no accident, no anything, no priors, just your basic DUI. It's a misdemeanor offense. Okay, it's a first-degree misdemeanor offense. It's punishable by a statutory maximum of the total time that you could get. Maximum on a first simple DUI is actually reduced to 6 months. even though it's a first-degree misdemeanor, okay? So I want to give you the minimums and maximums. I'm just going to run through them real quick. You can get from 0 to 6 months on a first DUI. You also, these are mandatory penalties. You will get a fine anywhere from $500 to $1,000. You will get a license suspension anywhere from 180 days to a year. And you will get a mandatory 10-day vehicle impoundment. You do not have any mandatory ignition interlock. That same first DUI, if you blow and your breath is above 0.15, meaning
Twice the legal limit.
less than half of what a POPCA officer just blew.
Right. Twice the legal limit, basically.
It's almost 2 times the legal limit. If you're above 0.15, or if you have a child, a minor, could be 17, but a minor in the vehicle at the time, then everything changes. Instead of facing 0 to 6 months, you face 0 to 9 months. So they tack on another possible 3 months. Instead of a $500 to $1,000 fine, it's a minimum of $1,000 up to $2,000 fine, right? And then, of course, the difference is in license suspension between 6 months and a year. You can imagine where the judge is going to go if your breath is enhanced or if there's a kid in the car. So what about a second DUI? Seconds vary because we break down seconds. Now, remember, if you pick up a second DUI, they're going to hold that first DUI against you. You're going to be double punished. So the variable with second DUIs is, did it occur within or outside of 5 years of the first DUI? If it's outside of 5 years, if it's 5 years or more after the fact, and after means after the completion of the sentence, not the date of the DUI and not the date of the plea. The date that you completed your sentence, meaning if you had a year probation, the date that your probation ended. If it happens 5 years after that, you still get enhanced, okay? So the enhancements, now you're looking at a minimum of $1,000 to $2,000 in a fine. You're looking at up to 0 to 9 months for jail time. So remember, it was 0 to 6 months on a first, it's 0 to 9 months on a second. License suspension, same, 6 months to a year. Mandatory 10-day period vehicle impoundment, but now you have a mandatory ignition interlock for a minimum of 1 year, okay? That's for a second outside. Now, if that second outside is enhanced, again, either BAC above 0.15 or a child in the car, then the fines go from $1,000 to $2,000 to $2,000 to $4,000. And instead of 0 days to 9 months, you go from 0 days to 12 months. So you see the enhancement. Take that same second DUI and now put it within 5 years of the first one. You have the same fines, 1 to 2,000, enhanced 2 to 4,000. But now you have minimum mandatory jail time. There's a 10-day minimum mandatory. So you have the same 10 days on the base instead of 0 to 9 months, or 10 days on the base to 12 months if it's enhanced. Correct?
Right. But at the very minimum, it would be 10 days at the very
and then
minimum.
for a third within 10 years of the first is a 30-day minimum. So the point of this is, and there's many more penalties, there's awful lot more to it, but the point to it is I want you to understand that DUI is a progressive crime. The legislature has specifically designed the penalties in such a way that every time you pick up another one, they get ratcheted. Just because you're committing the same offense.
Our entire criminal, almost you can pretty much say that the entire criminal code in Florida, as you said, Mike, is a progressive situation.
Well, yes, in terms of the way they can score your priors, but here we're talking about penalties specific to this offense that really don't apply to the score sheet, right? The score sheet doesn't contemplate, all the score sheet contemplates is minimum and maximum jail time. It doesn't talk about community service hours. It doesn't talk about, and these are things that are also non-waivable in a DUI case. I didn't get into all of that, but believe me, there are a ton of other.
But that was specifically written into the statute, so that's why that one's a little different. The
legislators, which is why I'm discussing it right now. But the same thing applies when we talk about theft. because in these theft cases, you have the same type of situation where you have enhancements and penalties. So if you look at the theft statute, which is 812.004, there are enhancements for theft that are really interesting. For example, again, with the victim aging, if you steal something from somebody who's older than 65 years old, then restitution and 500 community service hours are mandatory on top of any other penalty that the court imposes. The legislature has said the judge has no discretion. If you're found guilty, whether you plea or it's because you go through a proceeding and are determined to be guilty, there's a verdict, you must get those two things.
And you know why that was included? Because
we all have old people in Florida.
Clearly, the retired snowbirds from New York have a very strong lobby in Tallahassee.
Yeah.
And they're like, we're all going to live down here, South Florida. We don't want anybody messing with us.
Well, on top of that, if the state can prove that the defendant knew, not should have known, but knew that the victim was 65 and still committed the theft offense. Remember, we're only talking about theft here. Then it gets reclassified and bumped up a level. So if you steal what would otherwise be a second-degree misdemeanor, it becomes a first.
Right.
If you steal what would be a third-degree felony, it becomes a second, only because of the age of the victim and the fact that you knew it.
Wait, so they're not misled. If you steal and it's a first-degree misdemeanor, and you knew that they were over the age, it becomes a third-degree felony.
Right, exactly. But it also changes the numbers. And so I want to just give you guys this real quick. So for theft, remember we talked about different levels of crimes, right? Third-degree felonies, fourth. So theft is broken down primarily. There are other ways to break it down, but it's primarily broken down in terms of dollar value, right? So if you steal something that is $750 to $20,000 in value, it's a third-degree felony. If you steal something that's $20,000 to $100,000, it's a second-degree felony. If you steal something that's $100,000 or more, it's a first-degree felony. But they lower those values if your victim is over 65.
Right.
So if your victim is over 65, it's $300 to $10,000, $10,000 to $50,000, and $50,000 or above. So that's a significant difference, and for no change in value of property, but only based on the characteristics of the victim in your particular case. And then there are some things in the theft statute that are a felony no matter what their value is. So for instance, if you steal, let's say that I don't know how you might do this, but let's say somehow you steal a will or a codicil or a testamentary document, it's an automatic felony. There's no value for it. The fact that it is what it is makes it a felony. If you steal a firearm, it makes no difference what the value of that firearm is. It's a felony. It could be a $35 zip gun, or it could be a $4,000 custom rigged, hand pistol. It makes no difference. Motor vehicle. Doesn't matter if it was a junker worth nothing that didn't even run. It's still a felony. Commercially farmed animals, fire extinguishers, always felony. Doesn't make a difference what the value is.
So I can't steal my neighbor's cow?
Nope. You steal your neighbor's. Well, you can, but you'll be facing a felony. First degree misdemeanor is $100 to $750, and less than $100 is a second degree misdemeanor. So if you see, and the other thing with this is, if you have a prior petty theft conviction, then your second petty theft gets bumped up. So if you have 4 theft convictions, petty thefts, it's automatically a felony. So again, it's the repeat nature of this particular type of offense that makes it treated differently than other offenses in the state of Florida.
And I don't know if you want to mention now, at this point, or I don't know if you're ready to talk about it later, how it also includes the sentencing, for example, with withholds. When you and I first started, you could get as many withholds as you wanted.
Right.
Now the legislator has legislated that 2 withholds is all you get.
And
the third crime must be a conviction.
And you're not even entitled to 2 withholds. because a judge has to do specific findings on the record if the state objects. They've got to put on the record sufficient reasons, and if they don't come up with sufficient reasons, the state's going to win an appeal on that.
And in fairness, again, I know, but see how this keeps coming up? This is a recurring theme. You got to hire a criminal defense lawyer who knows what he's doing, because just like the legislator says, these are the rules and this is what it is, they've also given us a statute where Michael says the judge has to come up with reasons on why, let's say, to give you a third or a fourth withhold. Well, your lawyer, if he knows what he's doing, can present argument based on that one mitigating Florida statute's mitigation factors, which basically tells the judge, if you're thinking of giving my client a withhold, you can do it, and this is why, based on these facts. So again, it's really upon your criminal defense lawyer to let the court know my client qualifies for all these mitigating factors under the Florida statute, which I believe is what, 778? Do you remember, Mike?
It's a 775, but I'm not sure which.
778. I have it there. But you know, it's a mitigating factor statute, and you can go through and say, Judge, if you look at subsection, let's say F, my client qualifies under subsection F for you to mitigate his sentence. And while you would normally have to give him an adjudication because this is his third or fourth crime, you can give him a withhold because he qualifies under this mitigator. And that's what we're here for, is to let the judge know what's going on.
So I have a whole bunch of notes on withholds. We talked a little bit about them, but I just want to mention a few other things. There are certain crimes that you cannot get withholds on, even if it's your first offense.
DUI is one of them.
DUI, you cannot get a withhold. Domestic violence crimes, doesn't matter what it is. If it's stamped with DV, you cannot get a withhold.
Trafficking?
Fleeing and eluding, you cannot get a withhold. Trafficking, any first-degree felony, doesn't even have to be trafficking. All first-degree and capital felonies and PBLs are disqualified from withholds, with one exception, youthful offender. If you're categorized as a YO, you can get a withhold. And the exact language that the court is obligated to follow pursuant to the statute when they're giving a withhold over the state's objection, they have to quote, it's got to quote, be reasonably justified under the circumstances. That's what the statute requires. Right. I want to bang out a couple other quick things in terms of offenses. I want to talk about batteries and assaults, because these are other offenses that get jacked up based on factors that you may have no awareness of or ever acknowledge. But the fact that they exist changes the game. A domestic battery is different than a regular battery. If Ed and I get into an argument, or if we're at a bar or on the street, or we have an incident with somebody we don't know, road rage or whatever, it's not domestic. These are people who have no common connection. But if it's domestic, game changer. All sorts of other.
Explain what domestic is so they understand. It's not just husband and wife, boyfriend and girlfriend. It's anybody that you have a relationship. It could be your roommate. That could be a domestic violence if it's your roommate. So it's not just husband and wife or boyfriend and girlfriend.
So let me run through my notes real quick. Regular battery or assault are misdemeanors. Okay, if they're not aggravated in any way, they're just plain Jane, like a first DUI without any complications, they're misdemeanors.
And that's basically your bitch slap, a punch in the face, things like that, a shove.
But they get jacked up if you have a prior. If you have a prior battery, your second battery ain't a misdemeanor anymore. It's now a felony. If you have a prior assault, it gets bumped up just the same way. And you may recall that a couple of, I don't know, maybe it's a year ago now or so, but Governor DeSantis passed the anti-riot bill. So if you commit a battery in furtherance of a riot, that's also a felony, even if it's a simple battery. If it's in furtherance of a riot, provably, then it's a felony. But there are other ways that they can get jacked up. For instance, if you commit a battery, let's say that Ed and I get into a scrap and I smack him. I break his nose. I didn't mean to break his nose, but I broke his nose. I didn't intend it. All I wanted to do was slap him. He's just got a very sensitive nose, or he slipped and he fell and cracked his head open. Any of these unforeseeable consequences, you don't have to intend them. If great bodily harm occurs, your otherwise simple misdemeanor is going to become a felony.
Well, look what happened. Look, I could give a real world example. A couple of years ago, I represented a kid who was about 6'1", 6'2". He's 25, 26 years old, weighs about 160 pounds, soaking wet, no military training, no martial arts training, no boxing training, nothing. Just a kid who grew up riding motorcycles. Went out on a Halloween night, he thought his buddy was about to get jumped, and he came from across the bar and jumped over a couple of people on the dance floor and punched the guy that was going to punch his buddy on the side of the head. It wasn't even that hard. But when this man hit the floor, he caused some kind of a contusion to something in the back of his neck, or a vein in the back of his neck, that caused him to have an aneurysm, and he died. All he did was that simple half-baked punch. But because the guy died, they were looking to arrest him for manslaughter. So it turned out good for him. I got it. I got the whole thing dismissed, but it was a manslaughter arrest warrant.
So if you commit a battery and you cause great bodily harm without intending it, it's a third-degree felony. But if you do ag bat with intentional great bodily harm or with a weapon, it's a second-degree felony. So again, these things get ratcheted up based upon circumstances.
And let me just elaborate quickly also, Mike.
Wait, one more thing. Also, your regular misdemeanor battery becomes a felony if your victim is a law enforcement officer, a firefighter, an EMS provider, a public transit officer. Any of these type of people are given special protections, as are special victims like we talked about, somebody who's over 65 years of age. In fact, when it comes to somebody who's over 65, your basic battery or felony battery now comes with a minimum mandatory 3 years, as well as a mandatory $10,000 fine, $10,000 fine, restitution, and 500 community service hours. So all of these things get tacked on just because of the nature of the offense itself.
Let me explain something to the audience so they understand just how easily, what you, in common sense to you might say, this is not an aggravated battery with a weapon. How is this a weapon? No weapon was used. So suppose Mike and I get into a fist fight, but Mike hits the ground. And when Mike hits the ground, I kick him in the head, or I kick him in the ribs. I kick him anywhere. That is an aggravated battery with a weapon. And this is why, because the weapon is defined as something that is being used for a purpose other than what it was intended to be used. So when I kicked Michael that he was down, if I was especially if I'm wearing cowboy boots were not invented for me to kick people in the head. They're invented for you to walk. So the minute I took advantage of Michael being down and I kicked him in the head, a prosecutor could charge you with an aggravated battery with a weapon. You throw a coffee pot at somebody. That's a weapon. I know you're not thinking a coffee pot is a weapon, but remember what the definition is. Something that was used to commit the battery is being used for the purpose other than what it was intended for. So it's real easy to get an aggravated battery with a weapon, not a deadly one, but a weapon. If you use anything, if I poke Michael in the eyeball with a pen, that's a weapon. So these can be pretty complicated and they can enhance pretty quickly.
I want to hit two more traffic issues real quick. I want to talk about reckless driving and HTOs, which is license suspension issues. So again, these are stackable offenses. The more of them you get, the harsher it is. Reckless driving is a criminal traffic case. It is not. It looks like a ticket. It smells like a ticket. You don't have to be taken to jail, although you can be. They can let you go right on the scene. But make no mistake, it is an arrest and it is a criminal case, and you are looking at jail time. On a first reckless driving, which is a second-degree misdemeanor, it's maxed out at 90 days, not 6 months, but 90 days, 6 months probation and a $500 fine. But if you have a prior reckless driving, then your second one, you're looking at 6 months in jail instead of 90 days. You're looking at the same 6 months probation. And here it's a minimum fine where they must fine you at least $50 and they can charge you up to $500. If you have a reckless driving accident that involves property damage, first degree misdemeanor, 12 months jail, 12 months probation, $1,000 fine. And if there's serious bodily injury, then it's a felony. 5 years probation, 5 years prison, $5,000 fine. HTO is a designation that we use for certain career traffic offenders. If you rack up 15 citations, regular tickets, they could even be toll citations, which is a common occurrence. How many people run toll booths without having a sun pass, or the battery in their sun pass is dead for any of a number of reasons, or they lent their car to somebody and the sun pass wasn't activated. Much less regular tickets that you would get for any other situation, speeding, broken taillight, whatever. Well, it can't be a taillight. It's got to be a moving violation. But if you pick up 15 moving violations inside of 5 years, you are automatically designated as a habitual traffic offender. Similarly, if you rack up 3 qualified convictions within, or it doesn't have to be convictions because withholds count too. If you rack up 3 qualified priors within 5 years, those are driving on a suspended license as a general rule, then you wind up with an Hto designation. What's an Hto designation? It's a way to take you to felony court for driving on a suspended license, or for driving when you were designated as an Hto and knew you shouldn't have been driving. And it's very serious. Depending upon where you are, there are certain places like Monroe County where you will get prison time. Not jail time, prison time. They will send your ass to the state if you are an Hto driver, especially if you're going through key deer country. So they don't, I had a judge once look me in the face because I went down there with my Miami attitude on a speeding and a DWLS case, which here in Miami, if you have a driving on a suspended license, doesn't even matter if it's knowingly or unknowingly, it's irrelevant. As long as you have a valid license by the time you enter the courtroom, 999 out of 1,000 times that charge gets dismissed. I venture to say 1,000 out of 1,000, but there's got to be one here or there where it doesn't. It has never happened to me. I don't even know if I know anyone that it's ever happened to where they haven't gotten it dismissed here in date. But you go down to Monroe County or you go up to Broward County and try and pull that same thing, it don't fly. Monroe is much worse than Broward in that regard because they, like I said, they will throw your ass in a jail cell.
And I hate to say something, but let's be honest, especially if you don't live in Monroe.
I don't think that they care if you live there or not.
No, they don't. Listen, but I'm just saying.
All I can tell you is that this judge looked me in the face, and this is the exact line, which I will never forget as long as I still have my mind, okay? He said to me, Mr. Haber, you're from Miami. You have a lot of roads in Miami, but we only have one road here in the Keys, and we take that road very seriously. He wasn't joking.
No, he was not. So I've been down there. I actually dealt with a judge down there who's considered a real hard ass. But I got to tell you, man, he was fair and treated me wonderfully. Judge Garcia. You been in front of him?
No.
Apparently, he was a prosecutor. I can't remember if it was
I only go to the Keys to drink and fish.
Oh, I had to represent him. I had to represent a very nice client who was a bit of an asshat and just didn't understand that when you're on probation, you can't
self-representing, Martinez. Stop self-representing, Martinez.
He didn't understand when you're on probation, you can't just do whatever you want. I can tell you the facts, and you'll see why Judge Garcia was upset.
We don't have a lot of time.
30 seconds. It's funny. He got into a fight with his girlfriend. They were driving the News One. He was drunk. They got into a big fight. He didn't want to fight with her, so he got out of the car, but he was still about 5 or 6 miles away from home. So he passed by a gas station as he was walking home, and somebody left their car running while they were pumping gas. So he decided, in his words, to borrow the car just to get home.
Are you done amusing yourself?
I think it was pretty funny, man.
All right,
he stole some guy's car just to get home.
I want to talk real quick about the alphabet soup stuff, and I don't want to dig too far into the weeds, but I want to just give you guys a little bit of a understanding of what this is. So HFO is somebody with 2 or more prior felony convictions. Again, withholds are considered convictions for purposes of alphabet soup. So when you are in front of that judge and your lawyer is telling you take the withhold, you better be thinking a couple steps ahead about what happens if you wind up in front of the judge again.
That's your lawyer's job, is to tell you. That's something I wanted to get into.
I agree, but not every lawyer does their job, and that's why we're here telling people things that they ought to be looking out for. Don't simply accept, it's when you're paying a lawyer, or even if it's court appointed, you have the right to ask why. You have the right to ask, what does this mean? You have the right to ask, how will this affect me down the road? The problem is you might not get an honest answer, okay? Either because your lawyer is half an idiot and doesn't know the actual answer, or because they're intentionally trying to get you to close out the case and they just don't give a crap what happens down the road.
And as a prosecutor, I can tell you that one of the things we do when we see a very difficult case is sometimes we may concede to a withhold, knowing, for example, that you already have one, knowing that this one will now the next time you do something is going to make it an automatic conviction or things like
Well,
that. We take these things into account as prosecutors.
and prosecutors who are really on their game learn their defense lawyers real quick. They know the ones that are full of shit. They know the ones that come in there and plea everything out. They know the ones they have never seen in a trial. They've never seen pick a jury. And they know the ones who are going to take them to the mattresses and force them to do
And
absolutely everything.
you're talking to one. And that's exactly what I did over the weekend when I was in the pits and I would have to prep my trials for Monday. Usually you only have, the weekend or maybe starting from Thursday because the sounding is on Wednesday. So now all these guys came in and announced ready. But when I look across the file and I see Michael Haber, I'm like, shit, I better work on this one because if I don't get a good plea offer to Michael by trial, we're going to trial. But
Right.
then I'll look at some of the others who I shall not name.
And you can probably whack out 75% of your caseload just knowing
Right.
those lawyers are not going.
I'm not going to say who they are, but I will tell you
Doesn't
this.
matter.
They charge very little. I'll look at it and be like, this guy ain't going to trial.
I can tell you right now, Ed, some of them charge a lot.
Well,
okay, I've had some very big name lawyers that I've come in and taken cases over for because they've done dick all for the clients.
You're right.
And they charge them a fortune. It's not really the fee that designates anything.
I take it back. You're right. But
So
the point is this. We see the ones that aren't going to go to trial that we know will never be in trial. And I've never prepped it because I knew eventually he's going to force his client to take the plea. And if your lawyer is sitting there telling you, you're stupid, you better take this plea, he's probably one of those guys because Michael and I don't take anything personal. We tell you what we think is the best option. And if we think honestly, it's not smart for you to risk this and take it to trial, you should take this plea, we'll tell you once, twice, maybe 3 times. But if you keep telling us, no, I don't care, I want to go to court, I want to go to trial, listen, as long as Michael and I are paid, we go to trial. That's what you want. That's what you get.
All right, let me run through some of these things. For habitual felony offenders, you have to have 2 or more priors. They can't be from the same case. They have to be from separate cases. And then the new crime must occur within 5 years of the completion of the sentence. There's no other restrictions on that. If that's the case, everything that you were facing doubles. That's the basic rule for HOs. So if you have a 3rd-degree felony where you were looking at 5 years, if you're an HFO, you're now looking at 10 years for that same crime. If you were a 2nd-degree felony where you were looking at 15 years, you're now looking at 30 years for that very same offense. That's how serious HFO felony is, HFO designation is, and that's the least of the alphabet soup designations. From there, we go to HFVO, which is the habitual felony violent offender. And that's basically the same as the HFO, except it doesn't cover every crime in the book. By the way, for HOs, the one crime that's not scoreable, the one that you can't use, is simple drug possession. Just simple possession. If you're like possession of cocaine, possession of a controlled substance, that cannot be used to enhance you. But anything else can. But for an HFVO, the crimes are enumerated, and they're violent felonies. So you have to have those prior violent felonies, and you have to be accused of an enumerated current violent felony. And then you get jacked up through the roof for that. Just examples of some of those: arson, sexual battery, robbery, kidnapping, aggravated battery, aggravated stalking, etc., etc. When it happens there, you have minimum mandatories. Right. So it's not only does the maximum get enhanced, but you have minimum mandatories where the court must impose. So on a 3rd-degree felony, you have a minimum mandatory of 5 years. On a 2nd, a minimum mandatory of 10 years, and on a 3rd, a minimum mandatory of 15 years. So that's pretty significant in terms of now you know what you're looking at, because minimum mandatory means you don't get gain time, you don't get good time, you serve day for day for that particular period. And if you have you could get sentenced to 10 years with 5 years min-man, where you do the first 5 years day for day, and then once that's done, you start getting gain time on the second 5 years. So it's again, the math is there. I don't need to do it for you, but you have to understand this is how your priors come back to bite you in your ass. A prison release reoffender. Okay, this is somebody who commits a new felony offense within 3 years of being released from prison or completing probation or concluding their sentence, or while they are a fugitive because they fled. Again, the crimes are specifically enumerated, and the minimum mandatories become the statutory maximum. So remember I told you you're looking at 30 years on a first-degree felony? Well, if you're a prison release reoffender on a first-degree felony, your minimum mandatory is 30 years. How's that? That's a pretty serious, swift kick in the head. So that's enough on that, I think. I don't need to get any more deeper into the weeds on those. I left out violent career criminal, but we can live without it. I want to jump forward to 1020 life. 1020 life is a enhancement statute, and it was created at the time that all these alphabet soup statutes were created, when Florida really decided to come down hard on crime. I believe this was all under Governor Jeb Bush, and
Correct.
all of this stuff was pushed through. And basically, what 1020 life basically says is, it's got an awful lot to it, but the main functionality of it relates to firearms. Not all of it. There's some other stuff, and I'll give you as much as I can. But with regards to firearms, the general rule is this: if you pull a gun, you're done. It's a mandatory 10-year sentence if you pull a firearm during the commission of certain enumerated offenses. If you discharge that firearm, if you shoot, not hit anybody, but just discharge the gun, again, during the commission of those offenses, it's 20 years, that's the 1020, and then it's life, or it's actually technically 25 years to life if you actually strike somebody with a bullet. So that's the nutshell of 1020 life, but it also created certain minimum mandatories for other types of crimes that don't involve firearms. For instance, well, one does. If you're a felon in possession of a firearm, there's a 3-year minimum mandatory. That is a result of 1020 life. If you commit an aggravated assault against an aggravated assault or an aggravated battery on a police officer or on somebody age 65 or older, those all subject you to minimum mandatory sentencing under 1020 life. So there's all of these different types of ways that you can enhance your sentence. There's also, by the way, a habitual misdemeanor offender. And that is somebody who has 4 prior misdemeanor offenses. They've got to be qualified offenses. And it requires a mandatory 6 to 12 month jail sentence. There's no way around that if you're a habitual misdemeanor offender. So there was an awful lot of other stuff that I really, really wanted to get to, but we're up against it. So I just want to real quickly tell you that when it comes to your priors, Florida Statute 775.0842, person subject to career criminal prosecution efforts. A person who is under arrest for the commission or attempted commission or conspiracy to commit any felony in the state of Florida shall be subject to career criminal prosecution efforts, provided that person qualifies as a habitual offender, habitual violent felony offender, or a violent career criminal. That means there ain't no discretion here.
Well,
That means,
and I can tell you something. The state attorney is not going to. They're going to make sure that you get classified. They're the ones who file the notice of intent to enhance, and I can tell you that the state attorney's office is going to do it. They're going to do it for many, many, many reasons. One of them being it affects their budget. I don't know if you know that, Michael, but it affects their budget. So every time that you qualify, I'm telling you now, they're going to enhance, because that means that state attorney office in that county is going to get more money. So they're not playing around. That's what you really need to take from this. I know a lot of it is sounds like CLEs, where you're almost studying to be a lawyer, especially the way Mike presents it, because he's so thorough and he gives you all the numbers and the stats and the whatnot. But what you really need to take from this, if you're not a lawyer, is they're not messing around. Repeat offenders are going to be treated very harshly.
I just want to mention a couple other things, and I know that we need to go at this juncture, but I just want to mention a couple other things real quick. Why am I not?
Well, the good news is we're not up against a hard break, Mike. We don't have Hannity coming up next. We can go over a little bit. Today's show goes over just a little bit.
So there are other types of enhancements. Oh, here, this is what I was looking for. 775.085. Perfect. Okay. So I just want to give you a couple other types of enhancements that they have. 7750861. It's a one-level bump up if you commit offense against a person on the grounds of a religious institution. That means they have to be there for purposes of the religious institution. So if Ed and I are both at church and I turn around and punch him in the face, I'm going to get bumped up if that occurs in a church or in a synagogue or a mosque or whatever.
Synagogue, whatever.
775.0862, one level bump up for a sex offense against a student by an authority figure. So the same sex crime that you could commit against anybody else, if it happens to be teacher, student, or any authority figure in the school, it doesn't have to be a teacher, you're going to get a level bump up for that. 7750861, one level bump up for mental or physical disabled victim. Again, it doesn't matter what the crime is. It could be a battery, it could be a theft, it could be a robbery, it could be anything. If the victim just happens to be physically or mentally disabled, bam, you're getting a degree bump up. And then the only other one that I really wanted to hit was 775.085, which is hate crimes, or what we call evidencing prejudice while committing an offense. Okay, and that bumps everything up as well. And here's just so you know the language: it's any felony or misdemeanor which evidences prejudice based upon race, color, ancestry, ethnicity, religion, sexual orientation, national origin, homeless status, or advanced age of the victim. So now you know there are so many factors. Now, this is all on the backside of a criminal case. You have to understand, Ed and I are thinking about this when the client first calls us. But you guys are worried about, am I going to have to take a plea? Am I going to have to go to jail? How's my case going to get worked out? Do I need to go to trial? And what's it going to cost? Those are always the primary concerns. But for us, it's a bigger global picture. We're very concerned about the tail end right up front because we have to start working on potential mitigation even when we're working to beat a case.
Well, look, let me give him an example. Suppose, Michael, you come in and see Michael and I, and we're like, oh my God, they can throw 3 enhancements at my client, and it would take this third-degree felony to a first-degree felony, maybe even a life felony. Oh, Jesus. Well, now we go talk to the prosecutor, and at the first setting, they offer us a withhold and 1-year probation. I don't have full discovery, but you've told me, or Michael, what has happened. That might be where you and I, Michael and I, would sit down with you and say, listen, before somebody recognizes that they can take this third-degree felony and make it a life felony, you might want to take this plea and run. I don't have full discovery. What do you want to do? You want to wait for me to get the discovery to see what's wrong? There might be something wrong with the case, and maybe we can get it dismissed. You want to gamble? Because it's your life. It's like hiring Michael and I to play poker for you at Vegas with your money. It's your money. I'll bluff. Michael and I will bluff as long as you want. It's your money. It's not ours.
Well, at the end of the day, we'll give you options. So look, we've run over, and I apologize to everybody that we've taken a little more time. But again, this is it's just a monster topic. And we didn't even really get to talk about the whole point of why we got here, which was your 65 against 65.
No, it was 65 against a 71.
All right, but I mean, 2 elderly people.
Even older than the victim, which again goes into us making an argument of policy, which is not anything set in stone, but what was the legislative intent behind this? That's another argument that we have in our bag of tricks that hopefully we can get a judge to understand or a prosecutor to understand. But go ahead, Mike.
That's where we began, and so we're going to finish there. And that's what we were talking about and how we came up with the concept for today's show. So, if I am almost 57 and I strike someone who's 65 or older, I'm going to get enhanced. But what if I'm older than the person that I strike? Am I still going to get enhanced? Absolutely.
Yeah.
The state attorney is going to charge it. But as Ed said, is that what the statute contemplated? Is that why the legislature made this enhancement? Or did they make this enhancement to protect elderly from younger? And that's something that we would have to go do our homework and do our research, pull the legislative history, look at the notes from the legislative sessions, and then examine the case law, because there may be some interpretive decisions out there. But those are the services that you're getting when you hire Martinez or Haber. I can't speak to any other lawyer in this town. There are plenty of good ones, but you know what? There are plenty of crap ones too.
Right.
So eyes wide open. do your diligence, do your homework, ask questions. Even if it's a public defender, that's their job. Ask questions. And they should give you answers. They should happily give you answers.
Right.
Because the truth is, it's better to have an informed client who understands what's going on than an uninformed client who then complains later because they didn't know what was going on. With that, I want to thank everybody for tuning in today. Again, I apologize for running over a few minutes. This has been episode 43, and we will look forward to seeing you next week for certain with episode 44. I believe we have a special guest coming on next week, which we're excited to have. I don't want to promo it now because we got to lock it in, but if that's the case, you guys will enjoy as much as we will, and we'll all be honored to have Her Honor join us. With that, thank you for joining us. It's a pleasure to have been at your service, and we will see you next week. Take care, y'all.
All right. Bye-bye.